Hi, my name is Harvey Koning and I'm here with Greg Wright. We are lawyers at the Varnum Law Firm, and Varnum is proud to be a strategic sponsor of Manufacturing Growth Alliance. We are here today with a video on a new statute, a new development, the Corporate Transparency Act, that applies to MGA members. Greg, what is the whole CTA thing about?
So the basic idea is that the federal government wants to gather some information about who owns corporations, limited liability companies, and other entities created or operating in the United States. And so the federal government wishes to collect this information so that they can combat money laundering, terrorism, and other undesirable activities.
Doesn't the government already have this information? Don't they know who owns the corporations and LLCs out there?
The federal government does not. A lot of this information is filed with the states when a corporation or an LLC is created. It may be updated from time to time, but it's oftentimes inaccurate, infrequently updated, and not terribly reliable.
Great. So does this new disclosure requirement, does that apply to every corporation and LLC out there?
It applies to all reporting companies in the United States and those who are qualified to do business in the United States. There are some exemptions, which we can discuss a little bit later.
Very good. So if it does apply to your entity, what is it that a company, an LLC, a corporation needs to disclose? What type of information needs to be reported?
So for the reporting company itself, you'd need to provide the name, the trade name of the company, its address, and the employer identification number. For certain individuals who are beneficial owners of the company, who exercise substantial control over the company, or who are involved in the filing of the documents to create it, you would provide their name, you would provide their address, you would provide a copy of a driver's license or passport, and the unique number from that document, the driver's license or the US passport.
And how does all this information get reported? Is there a form or a website? How do people report this information?
There is. So FinCEN, which is the agency in the Department of Treasury that is administering compliance with the Act, has created an online website called the Beneficial Ownership Secure System, or the BOSS. And the BOSS is available now to take your information.
Not sure I like the new BOSS here. It all sounds very complicated. How does somebody supposed to figure out what to report, how to report it, what to put in the system? How do companies manage this?
Well, it is a complicated matter, in particular because many companies have a number of different entities with different attributes, and it needs to be, it's important that we take a look at each entity to determine what, if anything, needs to be provided. That information can be provided directly. You can conduct your own research and provide it, but it is a complicated matter. And as a general matter, I think it's best to reach out to your attorney to have a conversation about the various aspects of your entities, who might be exercising substantial control or ownership, and whose information needs to be submitted.
Okay. And this is all new in 2024. When is the deadline? When do people have to report?
That depends. If your entity was created prior to January 1st of this year, you have until January 1st of 2025 in order to file. If you create your entity this year, it needs to have its reporting information on file within 90 days of the creation of the entity. Going forward, past the end of the year, it'll be a very short period of 30 days. So it depends on when the entity was created.
Now, one more wrinkle. We're filming this in early March, and just last Friday there was a court case that a court ruled the law unconstitutional. Mm-hmm. Does that mean I can ignore it and not deal with it? What's a company in Michigan to do?
It's unlikely that you can ignore the CTA for now. There was a district court case out of Alabama that indicated that the CTA went beyond Congress's power to legislate. But that actual protection associated with the decision only applies to the plaintiffs in that case right now, which is effectively a small business association and its existing members. Beyond that, everyone else will need to wait for this case to work its way through the courts or for Congress to take action with respect to the issues that the court mentioned.
So what strategy do you advise, given this court case out there and everything? Should people go ahead and get this report in right now, or should they gather the information and wait and see? What are you telling the companies you work with?
I would do your homework now and plan on filing in the fourth quarter. The first reason for that is that once you are in the BOSS system, you have 30 days to update any information that changes. And so if you don't have to be in the system yet, it's best to wait a little bit. The second reason being because, as we see with this court case, There's a lot in flux. It is possible there could be further changes. And so why not wait until later in the year in order to file? That said, we expect there will be a rush at the end of 2024 to comply. And it makes no sense to wait until the fourth quarter to determine what you will need to do. Why not figure that out now and be prepared?
So have your ducks in a row, but hold off pushing the button just yet.
Exactly.
And mechanically, how does that work? Is that something a company can just go on a website somewhere and fill in the information, or is there help available to help somebody figure all this out? It seems kind of complicated.
So the system itself you can access through the internet individually, but this is a complicated regime, and we think it's best to have available to you the resources of an attorney who can work with you to make a determination as to who needs to file. We're working with a third-party provider that's providing access to this system as well. And if you work with, with a legal professional and a provider who can provide access, we think that will give you the additional information and resources you need to make sure your report is correct.
Okay, so a manufacturer out there can sign up with this vendor, send the information to the vendor, and the vendor would do the actual report then?
It would submit the information that's provided by the reporting company, yes.
Excellent. Is there a fee involved in submitting this, or how does that work?
Well, filing with the BOSS system itself is free. Obviously, there's the cost associated with performing the examination on your own business and working with professionals to provide you with the background that will support an accurate filing. But the filing itself has no cost.
Right, right. So, and the statute, it applies to all entities unless they're exempt. So what
Yes.
are some exemptions that might apply to a Michigan manufacturer out there to try to figure out, do I need to report? Do I not need to report? How does that work?
Sure. The most important exemption is the large operating company exemption. So if a company has reported more than $5 million in revenue on a U.S. tax return and has 20 or more full-time employees and a permanent presence in the United States, as most Michigan companies would, they would be eligible for the exemption. Likewise, if you're a subsidiary, wholly owned subsidiary of a company that is otherwise exempt, you may be exempt as well.
But if you're a manufacturer with less than 20 employees, unless some other exemption applies, it's likely going to sweep you up?
That's correct, yes.
Okay. Now, it seems like a lot of manufacturers would have already given this information to their bank to run against various lists and things. Does that take care of it or not?
It doesn't. Information that you provide to your bank under the Know Your Customer regime is provided directly to the bank for their regulatory reasons. This information is provided directly to the government for a separate obligation. We do expect that banks will have access to this information with your consent, and that they will check the two reporting regimes against one another to make sure they're consistent.
Yeah, this seems kind of intrusive. You're talking about driver's licenses, passports, that sort of stuff. What if I don't want to do it? I miss the deadline. I decide I'm not going to file. Are there consequences?
There are financial penalties, up to $500 a day or $10,000 in the aggregate for sort of a willful violation of the act. The actual aggressiveness with which FinCEN is going to enforce these penalties isn't entirely clear, but we don't recommend anyone plan on finding out.
Great. And once I report the information, am I done for good then?
No, to the extent that any of the information you have provided as a reporting company changes, and there could be many changes, a change in driver's license, address, owners, officers, and directors, all that information has to be reported in an update to your filing within 30 days of the change. So there will be an ongoing reporting requirement.
Well, thanks, Greg. This is new, it's complicated. Any other parting thoughts or advice for companies out there? If I'm a manufacturer in Michigan, I've never had to deal with this before, what should I be thinking about?
Again, I would recommend that you reach out to your legal professional to take a look at the company that you are operating and any other companies in its family, to make a determination in the first part of the year about what information you'll need to submit so that you're prepared in the fourth quarter to comply.
Thanks so much, Greg. We appreciate it. It's a big help to manufacturers out there. Thank you.
Thank you.